This field hearing of the Senate Health, Education, Labor, and Pensions Committee will be called to order. This hearing will focus on whether our federal laws are doing enough to protect people when they are at their most vulnerable, when they are sick and in need of medical care. Being in the hospital, even under the best of circumstances, is a stressful experience. When you or someone you love are in urgent need of care, nothing else matters. I think everyone has had the experience of powerlessness and vulnerability when you're in pain and you don't know what's wrong, or when your child or your parent or your spouse is hurting. And at that moment, the last thing on your mind is your wallet. That's why I found Attorney General Lori Swanson's report about Accreta's alleged activities at Fairview extremely disturbing. I would find it absolutely abhorrent if any patients had been badgered by debt collectors in the emergency room, or if any patients had been given the impression that they wouldn't be seen unless they prepaid for their care. That type of activity is not acceptable anywhere, and is certainly not acceptable here in Minnesota. I've read that patients in extreme pain were asked for payment for health services in Fairview's emergency room before they even knew what was wrong with them. And I've heard that parents of premature infants were approached about their bills while they were in the neonatal intensive care unit. I've even heard that off-site debt collectors had access to detailed protected health information about patients, including their mental health conditions and other diagnoses, which may be in violation of federal privacy laws. And I'm worried. I'm worried that if patients know they'll be asked for prepayment of services, that they'll stop going to the emergency room when they're sick, which isn't just dangerous for them, but it could result in the spread of disease and entire communities getting sick. And I'm worried that if patients hear that their protected health information isn't going to be kept private, that they won't share important information with their doctor, such as what medications they're taking. And that could lead to even worse health problems and higher costs if doctors don't have the information that they need. I'm worried that activities like the ones that have been alleged could bring down the quality of health care that Minnesotans receive when they go to the hospital. And that would be a real tragedy. Our state has always been a national leader in providing high-quality health care, and Fairview Health Services is a prime example. I've visited Fairview hospitals many times, and I've spoken at length with their doctors and their nurses. I'm convinced that they are among the best health care providers anywhere. And I think we'll hear from people today who will bear that out. But I also know that there's another part of the equation dealing with the administrative side of things, and so I look forward to working with Fairview and all of Minnesota's healthcare leaders to make sure that patients are fully protected. It's possible that the laws that protect consumers from debt collection and those that protect our privacy don't go far enough. And although we're still getting all the facts about the activities that may have taken place, I look forward to hearing from our experts about whether we need to strengthen the laws that protect us when we are at our most vulnerable. However, before we can move forward in strengthening never mind. I won't drink from the flat water. Before we can move forward in strengthening our patient protections, we need to understand what took place, and that's why I've called this hearing and asked our witnesses to testify today, because I want to hear all sides of the story. I'm not here to sit as judge or jury. I'm not here to resolve the dispute between Accreta and the Attorney General. That will be left to the court system. But I do want to find out what happened, to the best that I can, how patients were affected, and whether existing laws are doing enough to protect Minnesotans when they go to the hospital. Take the Health Insurance Portability and Accountability Act, or HIPAA, for example. That law is intended to protect both the privacy and the security of patients' sensitive health information. In this case, though, nobody disputes that data from more than 20,000 Minnesota patients were compromised. And it appears that debt collectors had access to more protected health information than they needed to perform their jobs. So that raises questions for lawmakers. Does HIPAA need to be strengthened? Does it require clarification? Is it being enforced adequately? Take the Fair Debt Collection Practices Act as another example. That statute puts in place important protections for consumers. It governs when and how debt collectors may approach a person about a payment. But there's a dispute in this case as to whether that law even applies to Accreta's alleged activities. Again, it will be for a court to resolve that dispute, but again, there are questions for lawmakers here. For example, are federal statutes sufficiently broad in their coverage to protect Minnesotans from abusive debt collection practices? And finally, there is the Emergency Medical Treatment and Active Labor Act of 1986, or EMTALA, as it is known, which was put in place to prevent the practice of patient dumping, where hospitals would turn patients away from the emergency room if they were unable to pay for their care. The idea here was that anyone who desperately needs help should get it regardless of their ability to pay. And I think it is important to remember the underlying goal of this law is to provide emergency care to everyone who needs it. I know that hospitals across the country are being squeezed right now. Reimbursements are low, costs are rising every year, and budgets are tight for everyone. And hospitals, particularly hospitals here in Minnesota, which provide such high-value care, deserve to be paid for the services they provide. But especially in this time of economic hardship, we have to make sure that those with the least voice are heard, and that patients aren't the unintended victims of budget shortfalls. And that's what we'll be hearing about today, whether patients are being protected and what we can do better to protect them. Now I'd like to introduce our first panel of witnesses. Lori Swanson is Minnesota's Attorney General, the first woman ever to hold that seat. She was elected in 2006 and re-elected in 2010 and has been named one of the top 10 lawyers in America by Lawyers USA in 2009. She previously served Minnesota as Solicitor General and Deputy Attorney General. Mike Rothman was appointed the Minnesota Commissioner of Commerce in January of 2011. Like the Attorney General, Commissioner Rothman has extensive experience with consumer protection issues. Prior to his current role, Commissioner Rothman was an attorney with Winthrop and Weinstein, PA, in Minneapolis. Thank you both for being here today. Please proceed with your testimony. First, I'd just like to take a moment to remind all witnesses to stick to 5 minutes of testimony today, although, as you know, you may submit your statements for the record. We're going to have someone, Catherine here, holding up some time warnings just to let you know, because we do have a lot of witnesses today and we want to get through this. So thank you, Attorney General Swanson, and please go ahead with you.
Well, Chairman Franken, thank you for expressing so much concern and compassion for America's patients and for holding this hearing, especially in Minnesota, where so many patients and Minnesotans can have the opportunity to participate. You know, charitable healthcare organizations in Minnesota, they get a lot of breaks from the taxpayers of Minnesota. They don't pay income taxes, sales taxes, property taxes. They get the privilege of issuing tax-exempt bonds. And so over the years, the Office of the Minnesota Attorney General has had a strong focus on whether charitable hospitals and healthcare organizations in particular operate in a manner consistent with their charitable tax-exempt status and duties. Following a compliance review of Fairview in 2005, which found that the hospital engaged in overly aggressive collection practices, our office entered into a court order consent decree with the hospital to reform and modify its billing and collection practices. We entered into a similar consent order with North Memorial as well as other hospitals. More recently, we initiated a compliance review of both Fairview and North Memorial to evaluate their compliance with the consent decree and also whether their conduct was consistent with the duties and responsibilities of tax-exempt charitable hospitals. At Fairview, we examined the delegation of management activities by a charitable hospital to Accretive Health, a for-profit Chicago company. The Fairview compliance report is complete. One of your next witnesses is Chuck Moody, the Fairview chairman and soon-to-be incoming interim CEO. I've worked with Mr. Moody over the last several months and can tell you that I believe he's in command in addressing our concerns and has great concern and empathy and compassion for the patients of Fairview. The compliance review of North Memorial is underway. The Fairview Compliance Review found that Accretive repeatedly ignored the court order between the hospital and the Attorney General. This chart is an email from an Accretive manager asking its collectors to sign an agreement that they were familiar with the court order, but then telling the collectors, don't worry, the court order won't change their behavior anyway. It's just so we can say we have it. This chart is a Fairview issues log from the very same month, finding that Accretive tried to collect money from patients who were current on their payment plans, that it sent 6,000 accounts to collections without ever having asked a patient for payment first, and that it sat on 300 payments made by patients, resulting in artificially high bills. This chart is from a Fairview internal audit in May of 2011 that found numerous violations by Accretive of the consent decree. This chart is a Fairview email to Accretive from September of 2011, advising Accretive that it was in violation of the consent decree, that its actions were resulting in numerous patient complaints and confusion for patients, and saying, we're not going to be able to keep doing business with you. This chart is from another Fairview internal audit in December of 2011, concluding that Accretive continued to ignore the consent decree and that it had violated the debt collection laws and the patient privacy laws. Senator, it's apparent from the compliance review that number one, Accretive thought it was above the law. Number two, that Accretive's management contract unduly incentivized the company to ignore the cultures and mission and duties and values of a charitable hospital organization. And three, that the hospital was unable to restrain Accretive. I'm going to focus in the interest of time on just one area of the compliance review, and that's bedside collection visits in the emergency room. Chairman, 20% of Americans face a life-changing event in an emergency room. It's where husbands lose their wives, wives lose their husbands, kids lose their parents, and parents lose their children. It's a place of both medical trauma and emotional suffering. It is a solemn place, and it should be and remain a very solemn place. This chart shows that Accretive differentiates itself from other companies with what it calls the Accretive secret sauce. And it uses words, very frankly, Senator, that are not befitting for a hospital or an emergency room, that are insulting to the patients. The document concedes that typical hospitals don't collect money in the emergency room. It then describes, though, the placement of collectors in the emergency room as one of Accretive's secret sauce ingredients. Now, I've personally met with about 25 patients who were hit up by the Accretive secret sauce. My office has interviewed and spoken with many others. About 20 of those patients and their families are sitting here today behind me, and I want to thank them for coming and being part of this hearing. Senator 201, they're here because they don't want any other patient in America to ever be subjected to the kind of tactics to which they were subjected. We've heard from patients who receive bedside collection visits in the emergency room while suffering from chest pain, strokes, blood clots, labored breathing, diabetic attacks, appendicitis, elevated heart rates, elevated blood pressure, kidney stone attacks, disorientation, and even while hemorrhaging blood. Some were asked to pay money while they were in so much pain they thought they were going to die. Others were asked to pay money while dazed and confused and disoriented. Some were asked to pay money while hooked up to morphine drips, heart monitors, IVs, or with tubes shoved down their throat.
I'm sorry, Madam Attorney General, but we are through your 5 minutes. Could you wrap it up real quick?
Yes, I will wrap it up. Many were laying undressed on a gurney in pain. Most had insurance, yet they were still asked to find their credit cards or checkbooks while suffering in the emergency room. Some were overcharged because the secret sauce aimed high and demanded that they pay too much money, and some had to fight for refunds. Others were surprised to be stop listed on early morning hours before their surgery will weaken suffering. Mr. Chairman, there is a time and a place to collect money, but that what these patients went through is not the right time or the right place. Our office doesn't enforce EMTALA, but we do regulate charitable organizations in Minnesota. Accretive's management contract unduly incentivized the company to scorn the culture, mission, and values of a charitable hospital. It's not appropriate for a management company to orchestrate this type of collection conduct at a charitable hospital that receives tax exemptions from the people of Minnesota. American patients deserve better. And Mr. Chairman, I thank you again for holding this hearing.
Thank you, Attorney General Swanson. Commissioner Rothman, please go ahead with your testimony.
Thank you, Mr. Chair. My position as Commissioner comes with important responsibilities of protecting consumers and the public interest. Specific to today's hearing, the Commissioner of Commerce has the powers and duties and responsibilities under Minnesota law to regulate collection agencies. Under Minnesota law, any collection agency doing business in Minnesota first must be licensed by the Department of Commerce. A collection agency must be a financially responsible entity, and any person wishing to act as a debt collector in Minnesota must register with the department. Minnesota law also sets forth a regulatory scheme for debt collection practices and activity. To maintain licensure and compliance with state regulations, no collection agency or collector shall engage in any of the following prohibited practices, among others: use or threaten to use methods of collection that violate Minnesota law, communicate with consumers in a misleading or deceptive manner by using instruments which simulate the form and appearance of judicial process, violate any of the provisions of the Fair Debt Collection Practices Law, the federal law, in collection letters or publications, or in any communication, oral or written, imply or suggest that healthcare services will be withheld in an emergency situation. When attempting to collect a debt, fail to provide the debtor with the full name of the debt collection agency as it appears on their license. The public has entrusted the department to enforce these regulations, and law-abiding debt collectors rely on us to ensure fair competition in the marketplace. These laws and our consistent enforcement of them are a crucial line of defense for Minnesotans, meant to protect their rights and dignity. The protections are particularly important for the most vulnerable among us: the poor, the sick, the disabled, the elderly, and those facing urgent health care needs. When our department receives complaints about unlicensed collection activity or other consumer issues, our staff works to carefully determine the merit of the complaints. When warranted, the department's review may move to the stage of a formal and comprehensive investigation, which may result in consent orders, formal statement of charges, administrative hearings, or settlements. With respect to Accretive Health, the Commerce Department has begun a thorough investigation of allegations that the company and its employees were conducting prohibited collection activity and had allegedly gone to great lengths to disguise its role as a collection agency from consumers. I directed the Enforcement Division at the department to look into these allegations to determine their merit and pursue a formal investigation. Allegations investigated by the department were based on the extensive complaint filed by the Attorney General. These allegations of unlicensed activity and prohibited collection practices raised serious concerns, and the Commerce Department exercised its regulatory authority to promptly put a stop to this activity in Minnesota. After an initial investigation, I signed a consent cease and desist order on February 3rd, 2012, that was agreed to by Accretive Health to summarily terminate any further collection activity until its collection practices came into full compliance with Minnesota law. Specifically, the consent order directed Accretive to, first, cease and desist from any further activity requiring a collector's license in Minnesota until it meets certain specific conditions, including full compliance with Minnesota law. Second, to provide copies of documents and evidence regarding communications provided to debtors in their attempts to collect debts, their screening process for hiring employees, training materials, and the policies and procedures for protecting personal information. The cease and desist order agreed to by Accretive Health was an important first step in ensuring the full protection of Minnesota consumers in response to these troubling allegations. We have a continuing full and detailed investigation. The details relating to this ongoing investigation are classified as private until the investigation is complete in accordance with Minnesota Chapters 13 and 45 under our statutes. The investigation will require, though, the full cooperation of Accretive Health. False and deceptive collection practices from any collector or collection agencies, licensed or unlicensed, will not be tolerated on my watch. I want to make it clear that to the extent the evidence collected in our investigation substantiates these allegations, such allegations would represent a severe and troubling disregard for consumer rights and a clear violation of Minnesota law. Mr. Chair, I appreciate the time. We take all our responsibilities seriously, and I am pleased to answer any questions.
Thank you, Commissioner Rothman. Attorney General Swanson, thank you for your testimony and for providing us with background on your investigation, which has garnered quite a bit of attention. I think that's probably because just about everyone needs medical attention at some point in his or her life, so these issues affect all of us. I know you've worked extensively with nonprofit hospitals across the state, and as you note in your report and in your testimony, nonprofit hospitals qualify for exemptions from all these different taxes that you laid out. In order to qualify for these tax exemptions, nonprofit hospitals are subject to specific federal and state requirements. Could you tell us about the agreements that you developed with hospitals across the state to make sure they're providing a benefit to the community?
Yes, thank you, Chairman Franken. In 2005, I think every single charitable hospital in Minnesota signed a agreement with the Attorney General's office, which was then renewed in 2007, and which we are in the process of renewing again for a 5-year period. That agreement was entered into after we did a compliance review that found troubling conduct, overly aggressive collection practices, and the agreement requires that hospitals have in place charity care policies, collection policies. They're to be approved at the board of directors level, making sure that in exchange for these significant breaks, the hospitals do good, provide charity care to the poor, and make sure people can still get their treatment. It requires the hospitals to undertake periodic audits of both their internal and their external collection practices to make sure those practices are in accord with various detailed written standards of our agreement, and as well to make sure those practices are in accord with the hospital's own policies. The agreements also prohibit both internal and external third-party vendors from engaging in aggressive, harassing, abusive collection practices. And so really the intent of the agreements were, number one, to make sure that hospitals were using what I call kinder, gentler debt collection practices, recognizing that hospital bills are different than other kind of debt, and that people are often, if you're sick, you need treatment, and especially in troubling economic times, not everybody can pay for that treatment immediately. And then also the agreements require hospitals to charge the uninsured the same price that they charge to insurance companies for the same treatment. Up until the time of that agreement, hospitals were charging uninsured patients, 3-4 times more than insurance companies for the exact same treatment. And so you had this perversity where patients paid an artificially high sticker price if they had no insurance that nobody else paid. The government didn't pay it, insurers didn't pay it. I think that the agreement really reflects what are community standards in our state, and would frankly be good policy for Congress to look at for the whole country.
What was Accretive's responsibility as a for-profit company contracting with Fairview, a nonprofit hospital, to comply with this agreement? And do you believe that Accretive violated your agreements, the AG agreements with Fairview and
Yes, Chairman Franken, Accretive specifically contracted with Fairview that it would be in compliance with all aspects of our agreement. That was something that Fairview wrote into the agreement with Accretive, is you've got to honor and comply with the Attorney General agreement. As I've pointed out, Fairview engaged in a variety of audits and was repeatedly warning Accretive that they were in violation of the hospital agreement and that Fairview wasn't going to stand for that violation. In many, many ways, they violated the hospital agreement, and we've laid that out in a whole separate volume of our report.
Do you believe that Accretive's activities at Fairview created a culture conflict with the kind of quality-driven culture that we expect from health providers here in Minnesota?
Chairman Franken, I do. One of the things that became very apparent during the compliance review is that Fairview has good doctors, good nurses, people who are very compassionate and view their work as almost missionaries to take care of the sick and the infirm and the ill. A charitable hospital, and especially an emergency room, should be a sanctuary to take care of people at the worst time in their life. I think that's certainly the values that have been expressed by the care providers at Fairview. On the other hand, Accretive, as a for-profit Wall Street money-making company, it wanted to create a numbers-driven culture at Fairview. We have a document in our report that says that we want it to be numbers-driven. The problem, Senator, is that healthcare isn't about numbers. It's about patients. It's about the patients sitting behind me today who, experienced very tough times in their life and had a collector visit them in the emergency room. And that created a collision in values, the culture of a nonprofit charitable institution on the one hand, and the culture of a very hyper-aggressive collection enterprise on the other.
It seems to me that hospitals are also in a tough situation. The cost of health care is increasing. Hospitals are being squeezed on the revenue side, and at the end of the day, they're operating on a very thin margin. Hospitals have to find a way to collect the money that's owed to them, and I'm sure you'd agree. And collecting payment from patients at the time they get care is one way to do it. A recent article in Forbes says, quote, "Increasing point-of-service collections has become a major weapon in the healthcare industry arsenal to bring bad debt under control." But the same article criticized your investigation into Accretive, saying that you were erroneously attacking an important billing practice. How would you respond to that criticism? Are you concerned with point-of-service practices generally, or is your concern with the way they were implemented in this particular case?
Chairman Franken, there is a time and a place for hospitals to collect money. There's a right way to do it and a wrong way to do it. What Accretive orchestrated at Fairview is the wrong way to do it. Hitting up patients in their bedside gurney in various stages of undress where they're hooked up to morphine drips or have feeding tubes shoved down their throats is not the time and the place to collect money. This is a time of medical distress. It's a time of trauma. Some of the patients who were hit up in the emergency room hadn't yet been on pain medication, and they were, as I mentioned, in so much pain they literally thought they were going to die. Other patients, on the other hand, were hooked up to morphine drips, and they were groggy, confused, disoriented, and the way that this company orchestrated the collection campaign was not the time and the place to collect money. Other times, patients were stop listed early in the morning, before surgeries. They were told, don't eat, don't drink for 12 hours. They got up at 3 in the morning to leave their house, came to the hospital at 5 for very, very important surgeries, only to be surprised to be stop listed and told, we need your credit card right now before you move ahead, at a time that they were weak and frail and suffering and groggy. That is not the time and the place to collect money. We have not tried through this compliance report to draw all the boundaries for point-of-service collections, but I can tell you the kinds of activity that we've outlined I don't believe is consistent.
Okay. Attorney General Swanson, I believe that when patients' privacy is violated, everyone is harmed. If patients can't trust that their health information will remain private, they'll be less likely to tell their doctors what conditions they have and what medications they're taking. In Volume 4 of your compliance report, you talk about the importance of privacy. You say that patients are less likely to be candid with their doctors if they think their information isn't private. What sort of protections are in place to protect patient's privacy, and are those protections adequate?
Chairman Franken, privacy is a bedrock principle of the doctor-patient relationship. 2,500 years ago, the Hippocratic Oath for doctors said, "That which I shall learn in the carrying out of my profession, I'll keep secret and never reveal." The idea being that patients need to know their information is kept sacrosanct, that it's going to be treated confidentially. I know that's been a concern of many of the patients who have come forward to our office, that they were concerned about their privacy. Chairman Franken, one of the things we've seen in our compliance report, we have a screenshot of the information about a particular patient who was on the laptop computer, and it lists her name and social security number on the laptop, whether she has any of 22 chronic medical conditions, including HIV, schizophrenia, bipolar disorder, whether she's depressed, what's her likelihood of future hospital treatment, is she frail? In another example in our report, we have a screenshot of the type of information that could be collected or accessed by the Kalamazoo, Michigan debt collectors of Accretive. And this particular screenshot is a fellow who was depressed and attempted suicide by cutting his wrist. You can only imagine what a debt collector can do with that type of information. Now, under HIPAA, there are certain privacy protections in place. One of those is that a hospital and a third-party vendor are supposed to have, in HIPAA parlance, what's called a business associate agreement, and that agreement is supposed to lay out what the protections will be and how data will be protected. As it turns out, Fairview had a business associate agreement with Accretive, only Accretive violated that business associate agreement. At North Memorial, as it turns out, there apparently was no business associate agreement in place at all. North Memorial entered into a contract with Accretive in March of 2011, and in October of 2011, I sent a letter to North Memorial saying, "Please produce to my office your business associate agreement with Accretive." In the few days afterward, there were a series of emails between North Memorial and Accretive basically concocting to create a business associate agreement and basically backdate it or retroactively date it for presentation to my office. Greg Kazarian, I think one of your next witnesses from Accretive, is on this particular email from the CFO of North Memorial. It's dated October 13, and it says, "Greg, we're sending you the BAA. Could you sign and return so we can include it with our AG response?" North Memorial and Accretive thereafter concocted a business associate agreement. It's dated March 21, or effective March 21 of 2011, and it was presented to my office as if they always had a business associate agreement. In fact, that agreement that was presented to my office was really signed in October of 2011.
Okay, that's that's news. Do you have those documents?
Chairman, I do.
Okay. I would like to see those.
I would be happy to present them. I think it would be very troubling to the patients that their information is being shared without that type of written contract.
Well, thank you. I need to move on.
Sure.
Okay. Commissioner Rothman, we have debt collection laws for a reason, to protect consumers. Can you explain why it's important that debt collectors register as such with your commission, why it is important that debt collectors disclose to customers that they are debt collectors and that they are calling to collect a debt?
Mr. Chair, it's vitally important. We have both requirements for the companies and the individuals to be licensed and registered by the individuals. It's important because we want to know who are the people that are authorized to do debt collection in Minnesota, and then therefore are also required to follow the law for what are prohibited practices. There have been other investigations that I've looked into in which debt collectors were either unlicensed, unregistered, or not eligible because of their prior history in terms of whether or not they're qualified. Meaning, for example, they cannot have certain criminal background history. And so these laws are meant to be a first line of defense against consumers generally, and then in particular in the context of medical profession, to also make sure that these are professionals and abiding by the laws of our state.
One of the issues presented in this case is whether the people who were collecting payments at at the hospitals and from the call center were, and I'm going to use the term of art, debt collectors or financial counselors. What do you make of this distinction, and why does it matter?
Let me speak to Minnesota law. Under our law, under Section 332, it defines what a collection agency is and what it means and who a person is that does debt collection. The collection agency means it includes any person engaged in the business of collection for others, any account, bill, or other indebtedness, except as hereinafter provided, which these exceptions don't apply here. It's a relatively broad definition. It's a little different than what the federal law defines as what a debt collection agency is. And a collector is somebody who acts under the authority of an agency to do those things. In Minnesota, Accretive Health did obtain and does have a license from the Department of Commerce to be a collection agency. Individuals who do debt collection activity under Minnesota law would therefore also need to be registered. And to the extent they were not, and if they were not, they would be serious and troubling violations of the law.
Okay, well, in the interest of time, I'd like to move on. I want to thank you, Attorney General Swanson and Commissioner Rothman. You're now excused. With the next panel, please come forward.
Thank you, Mr. Chair.